What's up, everybody? And this feels like deja vu because we are here again talking about Sarah Boone. If you want to know about this case, we are dropping a 1 minute, I almost said 1 second, quick case by case snapshot, which is a summary of a case within 1 minute, which is basically impossible. We're going to try to do it on a number of cases we're covering. So if anybody's not up to date on a case, you can go watch that and then jump into the playlist. Well, we are here for the 7th time. I say that a little tongue in cheek because a lot of the lawyers got off of her case for different reasons. But this, in fact, is Sarah Boone's 7th lawyer defending her on some heinous charges revolving around the death of her fiance and a deadly game of hide and seek. And this lawyer wants off the case. We have gone through many letters of her complaining about her lawyers, including the most recent letter that we just broke down in our last video for Sarah Boone, complaining about this lawyer, that he's not talking to her enough, he's not fighting for her hard enough, and now he responds. He doesn't let her write 3, 4, 5, 6, 7 letters. He responds basically to that letter with this motion. This is the motion to withdraw, motion for reassignment of court-appointed case. Comes now, Winston E. Hobson, the undersigned court-appointed attorney, and files this motion to withdraw and reassignment and states, counsel was duly appointed and filed his notice of appearance and demand for discovery. The accused is charged in the above-styled cause with second-degree murder in violation of Florida Statute 78204, subsection 2. Number 2, counsel has met with the accused at the jail and in video visits. So this is the first time a lawyer has responded to Sarah Boone's allegations where they're not meeting with her. They're not giving her the time of day. They're not talking to her. They're not preparing for her case. He responds and says that's not true. He says, counsel has met with the accused at the jail. So that's the individual meeting that I think Sarah Boone agreed with. And in video visits, plural. Multiple video visits and at the jail. Now, people have said, oh, you're not giving these lawyers enough of a benefit of the doubt. Some of them I have, some of them I haven't. We went through all 6 prior to this lawyer that got off the case, some of which I was with 100%, great reason. Other ones I thought you shouldn't give her this excuse and you should talk to your client a little more often than you are talking to her. People didn't like that. Well, I stand by the way I think lawyers should represent their client, which is not even the standard I would say that we do. We talk to our clients a lot more than these lawyers who, talk to their clients every 5 months or something, especially when trial's coming up. I just personally don't think that's enough. Okay. And if you want to disagree with me, that's fine. I'm not hating any of these lawyers. I'm not saying disbar them or reprimand them or things like that. I'm just giving you my opinion, which I think is why you come here. But this lawyer, he did something that the prior lawyer never did and said, that's not true. I am meeting with you. I haven't been on the case that long. So do I've already met with you once and multiple video visits. I am doing my job. He said, I've continued the work begun by prior attorneys in this matter, and I have also consulted with experts to appropriately position the case in the best interest of the accused, given the facts and the allegations in the accusations, meaning doing the best I can with what I got, Judge. So that's difficult, number 1. Number 2, he's continuing the work done by prior lawyers, which means he is fighting for it. He is picking up where they left off. He's trying not to waste a lot of time. That's good. That's important. That's exactly what he should do. A bunch of people have said that they believe this could have to do with them not being able to get an expert to say what Sarah Boone wants the expert to say. I am not picking that up in this motion, which, because it says, I have consulted with experts to appropriately position the case in the best interest of the accused. And if he said that didn't work or no experts will take the case and the client won't go forward without experts or something like that, I think we would have seen a little more between the lines here, as opposed to paragraph 3, which is the reason he's asking to withdraw. Irreconcilable differences, including but not limited to ethical considerations, have arisen in this case between the defendant and counsel, and it is in the best interest of the defendant that counsel be allowed to withdraw and the case reassigned to other counsel in his stead. There's a number of things we can learn from this vague paragraph that's kind of boilerplate, irreconcilable differences. We've all heard this in different contexts, whether it's, divorce or something like this. And the issue is this could be a million things. This could be the defendant is asking him to lie or do something illegal and he doesn't want to, and he doesn't want to make an ethical violation. He also can't violate attorney-client privilege, so he's kind of stuck. If that's the case, I don't know how reassigning and putting new counsel on the case is really going to help, but he wants to be off. Number two, I could see it as he hates the client now because she's publicly saying he's not doing his job and publicly lying about him and defaming him and making him look bad, and it's not true, and he can't really defend himself without violating attorney-client privilege. And because he really hates the client now, it's not a great position for the client to have a lawyer who hates you. Again, not saying that's what it is. I'm just saying some of the different reasons in the past we've seen for irreconcilable differences that result in ethical issues that should result in a lawyer withdrawing from the case. Now, we have seen many times lawyers file a motion to withdraw in other cases, and we have filed it in some of our cases as well, usually criminal cases. Sometimes they are granted, sometimes they are not. We have seen them granted for Sarah Boone. We have seen them not granted for Sarah Boone. We have seen them not granted for Chad Daybell's attorney. Just recently, John Pryor tried to do this. There was a whole motion, inquiry, and you heard the judge's reasoning to deny the motion to withdraw. It was too prejudicial to the defendant. And it's basically just about money. But we have a situation here where it's pretty early on in their representation. There is a trial date in just a couple months. Will the judge let Mr. Hobson off the case? Now, the first thing is, has there really been that many wasted resources on Mr. Hobson? On lawyers generally for Sarah Boone, the answer is yes. But on just Mr. Hobson, I'm not so sure that there have been that many resources wasted trying to get him up to speed on the case in just a couple months. So that's going to be a consideration the judge is going to take into place, that for Chad Daybell, it was years, and it was going to be extremely difficult and complicated to get anybody else. I don't think that we have that check against Mr. Hobson. But number two, is it going to cause major prejudice to the defendant? And if we really want this trial date in May, I think it's May, and he has already kind of gotten up to speed on the case and is talking to experts and has filed a motion for more funds, is somebody else going to have to come and redo all of that? We're going to have to kick the trial date. Is it going to prejudice the defendant too much? The answer may be yes to that, maybe no to that. But the biggest question, the biggest thing I want to know, which we've said it before for Sarah Boone, we said it for Chad Daybell, we've said it in a lot of cases, what does Sarah Boone want? Now, many of you are going to say, I don't care what Sarah Boone wants. And I understand that. But I ask the question because if she also wants Mr. Hobson out, it's a higher likelihood that the judge would allow him to withdraw. But when you're coming on, I am Henry VIII, that's what it's reminding me of, because this would be her 8th attorney. When does the judge say enough is enough? There's no rule in place. There's no guarantee that you get counsel of choice as appointed counsel. So maybe the judge says, listen, Mr. Hobson, make it work. Or maybe he'll have to say that to a future appointed attorney. But she does not get the same access to counsel of choice that somebody that's hiring a private attorney does. So the judge can't just keep cycling attorneys in here one after another. Now, some had conflicts, so it's not like she's booted 8 or 7 different attorneys, but she's had a lot. And there's been a lot of time, a lot of waste, a lot of complaints, a lot of issues. So the judge may force them to stay, or he may tell Sarah Boone, this is your last lawyer. If you don't make it work with this lawyer, you can represent yourself. Very unusual and unlikely. I would be shocked if that happened. But at some point, the judge is going to have to step in and say, enough is enough. This is it. I couldn't believe it when I saw this fast, that Mr. Hobson's out. I don't know how much he knew about Sarah Boone in this case prior to taking it on or being appointed. But now he knows what it's like, and he doesn't like it. I cannot wait to read your comments on what you think about this. Whether you think this guy should be allowed to withdraw, or should he just be forced to suck it up for the next 3 months? He's getting paid his court-appointed fee. Try the case and do your best. And if Sarah Boone wants to lie on the stand or do something crazy, put her up on the stand and you sit down at counsel table and let her talk, but you're not going to be a part of it. There's ways you can get around asking the client questions that you know she's going to lie to the answer to. If that's the case, I'm not saying it is. But this is getting wild. And at some point, enough is enough. And we got to say somebody's crying wolf and just say it's time to send this case to trial. And we'll see if we've gotten here. I can't wait to hear what all of you think. But those are my thoughts on the motion to withdraw. I kind of think the judge is going to say no at this point. Say it's too soon, try to work it out, try to make it happen, trial's coming up. Unless maybe something is revealed in chambers that's privileged that I don't know about, that really did happen, that's going to allow him off the case. Especially if Sarah Boone says, I want this guy to continue being my lawyer, I think the judge is going to force him to stay on the case. If Sarah Boone says, I want him out, then it becomes a more difficult decision because now we're just frankly looking at when is enough enough. All right. That's all I got. I'm going to come back and check your thoughts later. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.